Hello again, my name is Douglas Pinkham with Pinkham and Associates. We are a dedicated divorce and family law firm in Orange County. But keep in mind, we can assist you if you need help throughout the state of California. So no matter where you are in the state of California, we could still give you advice and help you out on most family law issues. This video is specifically about the FL 170, the Declaration for Default and Uncontested Dissolution or legal separation, depending upon which case you have filed. So, much like every form, at the top, you're going to put your name and address, phone number. Then under attorney for, you're going to put your name. Again, under the county, put the county in which you have filed all your paperwork and the street address of that family law courthouse that you are filing your documents in. And then, of course, it asks for the branch name of the court that you're filing your paperwork in. So if there's only one branch, family law branch in your county, you're just going to list that one branch anyway. Then you list the petitioner and the respondent. Again, as I've said every time on all of these forms, the petitioner and the respondent never change. So whoever was the petitioner in the original filing of the petition, they're still the petitioner throughout the entire case. If this is a declaration for default and uncontested dissolution, mark that box. If it's for legal separation, like connected to a legal separation judgment, or then you'd mark this box. Okay? And then, of course, you're going to list the case number over to the right. Okay? So if you are okay, so what this form is about is it is giving the clerk and the judge some information with regard to certain issues in your judgment. So it's going to ask about custody and visitation issues, child support issues, attorney's fees, spousal support. And what this form is sort of a shortcut for the clerk and the judge to get through your judgment. So you're going to need to mark these boxes correctly. If you are filing a judgment with respect to the petition that you filled out, you're going to mark this box. If you are the respondent and you're filling out this form, you're going to mark the response because you want it based on your response. This box means that all of the information in either your petition or your response were true and correct when you filed it. Okay? If you filed an amended petition or amended response, you're going to mark this amended box up front. Okay. 90% of the time, it's the petitioner filling this out, and there was only a petition, not an amended petition filed. So we'll just mark the petition since that's the normal route. Okay. I have some boxes marked here. We'll unmark them so that we can go through line by line. 4 asks for the type of case we're dealing with. And there are a few different types of cases that you might be using this form. One is a default without an agreement. That means that the petitioner took the respondent's default and they're moving through this case alone. And you're putting a judgment together now and the respondent was not even involved in the case. If this is the case, mark A. If there are no assets or debts to be disposed of by the judge, you can mark 3A. If there are assets and debts that need to be divided by the judge, you're going to want to mark B. And ultimately, you're going to need another form to go with this to describe those assets and debts. You might want to look up the FL 160. That's a very handy form for dividing property. One special note. Many people, when they're doing their paperwork on their own, want to mark 3A and say there's no assets or debts to be disposed of by the court. Keep in mind, anything that you purchased or any debt that you incurred during the marriage is presumed to be community property. And if you don't mark it and don't divide it in your judgment, it still belongs to both of you. So let's say, for example, you bought a car 2 years into your marriage, and it's in both names, and it's just, but the other party drives it, and you want to give it to the other party, and you don't want to fight about it, and it's not even a big deal. It's not even worth any money anymore. You still want to mark B, and you want to list that piece of property, that vehicle, and give it to the other party, because if you don't, it will always belong to both of you. And it's a special problem if you're a registered owner on that vehicle. What if the other party gets in a car accident? You're still owner of that vehicle. Just one particular issue. Let's say, for example, you've got bank accounts, your own bank accounts. You want to list them and give them to you in the judgment so that they don't still belong to both parties. Important stuff. Okay, you could also be doing a default case with an agreement. That means that you took the other party's default, but you have now gotten together and you're working on a judgment together, and you're going to agree on all the issues. Then you want to mark B. Let's say, for example, there wasn't a default. Petitioner filed the petition, served the respondent then filed a response, and now you're working together on a judgment so that you don't have to go to trial. Very, very, very common. This is great. Congratulations. If this is your case, you're doing good. Then you're going to want to mark uncontested, and then you're going to move on to 5. Declarations of disclosure. Declarations of disclosure are absolutely required when getting a divorce in California. You need to disclose to the other party everything you know about income, expenses, assets, and debts. If you have not done that, then the state of California can't even give you a divorce. So it's a big deal. It's really the thing that the state of California is most interested in and most concerned about in your divorce. They don't care how you divide your property. They really don't, in most cases, as long as you guys agree. But they don't want you dividing your property until both of you have disclosed to each other exactly what you guys have. So that's the important concept to be dealing with there. So let me mark this. So under declarations of, oh, by the way, I also have done a video, a very, very detailed video on declarations of disclosure. So you can go view my video on how to do your declarations of disclosure. And I go through each form line by line and very, very detailed information on how to do your declarations of disclosure. But after you've done your declarations of disclosure, you need to do a proof of service of that and show that they were disclosed and that they have been served on the other party. If that's the case, if both of you, the petitioner and the respondent, have filed or are concurrently filing the declaration regarding service of declaration of disclosure, that's the proof of service of declaration of disclosure. It's an FL 141. If you are submitting that and an income and expense declaration, FL 151, and by the way, I have videos on both of those forms also. But if you are submitting those with this judgment packet, then you can mark this box. That's not very often, so we'll move on to the next box. 5B, you're going to mark 5B if this matter is proceeding by a true default and the petitioner in this action is not, has filed their proof of service of preliminary declaration of disclosure, but they're not interested or not worried about receiving the declarations of disclosure from the other side, and you're willing to waive it. Then you can mark this box. 5C says that you guys are working together, just like we marked up here, uncontested. So this is proceeding as an uncontested action. We're working together, and we've done our declarations of disclosure, and we are going to file a declaration. We're going to waive our final declarations of disclosure and file a form, an FL 140, that says that. Now keep in mind, both parties must do a preliminary declaration of disclosure if you filed your paperwork in this case. But you're also supposed to do what's known as final declarations of disclosure closer to the end of your divorce process. This box, if you're working together, you can waive your final declarations of disclosure by simply filling or signing this form, which is a stipulation and waiver of final declaration of disclosure, FL 144. Okay, so let's go back to our form. So just thought I'd show you that form. Very handy form and necessary if you don't want to do final declarations of disclosure. Now moving on to 6. If you have children, you're going to need to mark this box. I'm going to unmark all these boxes here. So if you have children, you're going to need to mark the child custody and visitation box, and you're going to need to attach a form that sets forth your visitation plan. Also, 6A asks the information in your original declaration under Uniform Child Custody and Jurisdiction Enforcement Act. We call it a UCCJEA form. It's an FL 105. You filed it when you filed your petition or your response. You had to, or they wouldn't have filed your case. If you have children, it's necessary. In this form, it asks you if the information that you put into that FL 105 has changed. If it has changed, mark this box, and you're going to need an updated FL 105. If it has not changed, then mark has not, and you're done. If there are existing court orders for custody and visitation, a parenting plan, you're going to want to mark B, and then you're going to want to put the county and the case number over here. If the current custody and visitation orders have been made in this case, you're going to want to mark C and list that information here. If there are no orders, but you want some orders, you're going to want to mark D and put some information to help the judge make these orders. You're going to want to spell that information out here. This is done in default cases. So if you have taken the other side's default, you're not agreeing on anything, the other person's not even involved in the case, you're going to want to mark D and set forth in here. Or if this isn't enough space, make an attachment and just call it attachment 6D. And you're going to attach it to this form and spell out your information in that form. Okay, then of course if you have children, you're going to need to mark this child support box and deal with the child support. If child support has already been, if child support orders have already been made in another county, you're going to mark A1 and you're going to put that information over here, the case, the county and the case number. A2, if the information is in a child support calculator, often called, there's a couple different programs. We use a DissoMaster and we use one called an X-Spouse. You can look them up online. You can put your information in there and then print it out. If you print out that calculation and you can attach it to this form, that'll spell out how much child support is being paid, then you can mark 7A2 and move right along. If you don't have that calculation, then you may want to mark 3 and say you request this order be based on the other party's ability to earn income. This is hard to get, and you're going to have to probably prove this to a judge. You're probably going to have to go in front of a judge and prove their ability to earn. This is really, really hard to do in default cases. So don't plan on that. The easiest method here is to find the calculator online, put your information into the calculator, print it out, and attach that calculation to this sheet and mark 7A2. Okay. 7B talks about if either you or the other party are on public assistance. If they are, or if you're not, either way you need to complete B. Okay. If one of you is presently receiving public assistance, fill out C. You're just going to mark which one is receiving it, or both. If spousal, with regard to spousal support, number 8. Now, there may or may not be spousal support orders sought or even asked for. But you can mark in here what applies. 8A, very dangerous box. I recommend not marking this box no matter what. But it says you knowingly give up forever any right to receive spousal support or partner support. Keep in mind, if you mark that box, or if you mark C and mark your, let's say you're the petitioner and you mark this box, or if you mark it for both of you, it says I ask the court to terminate forever spousal support or partner support to you or both of you or whatever. Keep in mind, if you do this, you can never walk back into court in the future and say, I made a mistake, now I'm not making any money, or I got injured, or I got sick, and now I need support. You're not going to get it. Once you waive it forever, it's gone forever. So keep that in mind. You can, if you're taking a default, you can ask the court to terminate forever spousal support issues to the other party. Can do that. Let's say, for example, you don't know what you want to do. You can mark B and ask the court to reserve jurisdiction to award spousal support in the future. That just means you're allowing the court to keep it on hold, and you might want to visit it later. Okay? Or let's say that you and your spouse are doing a judgment together, a proposed judgment together, and you've agreed on a spousal support figure. You can mark D, and you can say that that spousal support is going to be enumerated or spelled out in your attached paperwork. There is a spousal support. Let me get it. Okay, it's an FL 343. If you do agree on a spousal support order, you can use this FL 343, mark this box on the top, judgment, that it's attached to a judgment. Then you're going to fill this out, and then you're going to go back and reattach it to your FL 170. It's a very handy form. And then what I would do is down here, I would put attached FL 343 to show that there is a spousal support document attached. Okay? And that takes care of spousal support. Then we move on to parentage. Parentage is only marked if you and your spouse had a child out of wedlock before you got married. Then this would apply, and you have to decide whether there was a voluntary declaration of paternity that was signed, and you can attach it, or you can fill one out now, or if parentage was established by another court in a different county, or if you guys have a written agreement that says that you are both also the natural and biological parents of this child. Then you could mark that box. Okay? Not very, very, very rare. So probably won't apply anyway. If you have attorney's fees orders that you have agreed on, you're going to want to mark 10 and say that and there's a form for that too. And you can use the FL 319 to specify what your attorney fee agreement is or your award is. If there's not any attorney fee award or orders, leave it blank. Don't worry about judgment nunc pro tunc. If this applied to you, it's very technical and difficult to get. It just means that you're asking the court to grant your divorce on a previous date, on some earlier date than today, like a year and a half ago. There have to be very, very good reasons for that. And it's technical, it's hard to get, and you have had to already get an order from the court to allow this, so which typically comes from a motion. You're not going to mark that box on this thing. 9,999 times out of 10,000, you're not going to mark that box. Okay, and then, but if one of you is asking for your former name to be restored, then you're going to mark 12. If one of you changed your name when you got married, you're going to mark 12. And then say, well, the petitioner or the respondent, whoever wants to change their name back, you mark that box. And on the judgment, the actual judgment form, you're going to spell out the name that you want it changed back to. On that form, it's the FL 180. Make sure you spell out the entire name, including your middle name. Okay, that's it for this form. That is the FL 170, the declaration for default, and uncontested dissolution or legal separation, depending upon which case you have. Thank you. And again, my name was Douglas Pinkham with Pinkham and Associates. Keep in mind, we work in Southern California, but we can help you out and assist you with your paperwork and information that you may need no matter where you're at in the state of California. Thank you very much. Have a great day.